welcome to this book launch of Animals and the Constitution. As those of you who have attended in the past may not have seen now, this is a webinar rather than an open talk, which alas means that we cannot see you or hear you. So what that means is that when the presentation and discussions are over, you'll still have an opportunity to ask questions and have them answered by the authors, but alas, you'll have to write them in the chat and I will then read them out. So that's how it will work. Apart from that, as usual, we'll be recording up and during the presentations, and then we'll stop the recording for the Q&A session. So, my name's Sean Butler. I'm delighted to welcome Raffael and John to present their book. And I'm also very, very pleased that Angie, Pablo and Saskia have agreed to present their responses to the book. Since I'm here first, I have to say I thoroughly enjoyed the book. I wasn't expecting to. I won't lie, constitutional law seems to have dogged me my entire life. And I thought it was absolutely fascinating. Have to say I'm not sure about the 30% representation, but no doubt we'll come back to that. All right, so unless there's anything else I need to add, the order will be that Raffael and John will present the book, and then Angie, Pablo and Saskia, in that order, will give their responses. So, Raffael, John.
Thank you, Sean, for the kind introduction, and thanks all for being here. Sorry, we had some technical difficulties there in the beginning, but we made it work. So we're really delighted to be able to share our work with you, and I'm just sharing my screen as well. I hope everyone can see this. So John and I are briefly going to talk about the book, give you a bit of an overview of what it's about, and then we really look forward to hearing from our brilliant respondents. I really can't wait to see what they have to say about the book, but I take it most people won't have had the chance to read the book yet, so we wanted to give a bit of an overview. It's a very hot day, so really appreciate you all being here. Certainly those who are in a sort of climate like the one we have here. It's 31 degrees. Right, so this is our book, and if anyone wants to get a copy of it, you can use this discount code here. It's still going to be pretty expensive, I'm afraid. I think it'll take the price down to something like £70, but at least it gives you a 30% discount. Perhaps you can also access it via your respective universities if you have access through that. So here's a table of contents. The book is divided into two parts. So we have the first part that looks at the status quo of constitutionalism, which is anthropocentric. In other words, it's centered around human interests and it privileges human needs. We then make the case for what we call sentience-based constitutionalism, so a constitution that is centered around the interests of sentient beings. And then in part two, we try to reimagine what basic constitutional principles like fundamental rights, proportionality, rule of law, and democracy would look like in a constitution that didn't just cater for human interests, but also for the interests of all governed sentient animals. So in a nutshell, then really the book is about trying to reimagine current versions of constitutionalisms that are anthropocentric and make them more attuned to sentient beings. So that's broadly the outline. I'm going to talk to you briefly about anthropocentric constitutionalism and sentience-based constitutionalism, and then I'll hand over to John, who will zero in on two of the chapters from part two. So what about this anthropocentric constitutionalism? What exactly do we mean here? What is the status quo of constitutionalism around the world? So as we show, and we don't focus on any given jurisdiction, but on sort of legal systems broadly around the world, there are four ways in which this human-centrism, this anthropocentrism, manifests itself in law generally, and then also four ways in which it manifests itself in constitutional practice and constitutional theory specifically. So starting with how it manifests itself in law generally, there are four ways really in which we can see that constitutions really revolve around human beings. First, it's the fact that for the most part, only humans are recognized as having intrinsic moral value, as mattering in and of themselves for their own sakes, rather than just because they're instruments for someone else. We see how humans don't have a use paradigm applied to them in the ways that animals do. So animals are subject to a use paradigm, which means that they are resources that can be exploited for human purposes. So they're instruments that can be exploited for human purposes, and that's sort of manifested in many different aspects of legal systems, including the fact, thirdly, that animals are ownable things. They are property. There are some legal systems that have tinkered with that have what's called de-reified animals. They've turned it into something that's not a thing in the strict sense, but for all intents and purposes, even in those legal systems, animals are still treated as property for the most part. And then lastly, we find that legal systems have human-centric concepts at their heart. Now, some of these human-centric concepts are sort of explicitly human-centric. So you find the standard of the reasonable person, for instance, in tort law or criminal law. So that's very much centered around the human being, a human person. Sometimes it's a reasonable man even, so a more sort of specific slice of humanity. And then there are also concepts that aren't explicitly human centered, but that implicitly are interpreted in ways that promote the interests of humans and exclude non-humans. So if you think, for instance, of legal personhood, there's nothing per se about legal personhood that makes it applicable only to human beings, but in practice, only human beings are recognized as legal persons, and indeed corporations that ultimately serve human interests. Then there are 4 ways in which anthropocentrism is manifested in constitutional practice and constitutional theory specifically. And they're really the 4 themes that we will return to in part 2 that John is going to talk to you about. So first, only human beings are recognized as holders of fundamental rights, so holders of thick rights. I need to put an asterisk here because there's some very limited exceptions in some jurisdictions that have granted through the sort of judicial avenue some limited fundamental rights to some limited animals, but for the most part, only human beings have fundamental rights. Second, the protections of proportionality only apply to humans. So this relates both to proportionality in a general sense, so as far as sort of making the measures that a state takes to achieve a certain end proportionate to that end. We don't really see that being applied to animals. And then also proportionality in a specific sense. So when it comes to rights balancing, animals are not afforded with the protection that the proportionality balancing test in particular, gives to human rights. In the way that indeed humans benefit from when their rights conflict with one another or with the public interest. And then thirdly, the rule of law. Animals do not benefit from rule of law protections because, as we'll see, and John is going to talk about this to some extent and at some length, the rule of law has a rational human agent usually at its center, rather than perhaps those more broadly that can suffer from arbitrary power. And then lastly, animals are not considered part of the demos. They're not part of the people who need democratic representation, right? So that's another way in which anthropocentrism manifests itself. The book talks briefly about the trend that we are seeing in constitutional law and constitutional practice towards granting more protections to animals in constitutions, and indeed more broadly constitutions that enshrine animals and animal protection in some way or another. And we show that although laudable, this trend doesn't really, in fact, doesn't at all get us close to a sentience-based constitution as we envisage it. So it is not enough. So what about sentience-based constitutionalism then? The second chapter makes the case for why we should abandon the dominant anthropocentric model and adopt this sentience-based constitutionalism, as we call it. So the argumentative move here at its core is we look at what we call a legitimacy gap that exists with anthropocentric constitutionalism. And that gap is effectively the following. Anthropocentric constitutions, they govern the lives of non-human animals, but they don't take into account their interests when doing so. And that creates a gap. Those constitutions aren't as legitimate as they should be because they don't take into account the interests of all those that they govern. What's the origin of this legitimacy gap, this problem at the heart of anthropocentric constitutions? It's what we call the sort of the legitimating principle that underpins the classic model of constitutionalism that emerged at the at the end of the 18th century. So with the emergence of the American Republic, with the French Revolution, we see a shift away in constitutional thinking from a justifying rule in virtue of a divine right of kings, and toward a sort of model that's based on the idea of the consent of the governed, right? So anyone governed by a constitution, should have the ability to give consent to that sort of governance structure. And if they don't give consent to it, then rule of that governance structure is illegitimate with regard to the person who refused consent. Now, because not everyone actually has the opportunity to give consent, the assumption is basically one of hypothetical consent. So would people give hypothetical consent to that constitution if they were given the possibility to do so? We think there are two problems with this legitimating principle. The first one is that focusing on consent of the governed marginalizes human beings who don't have that rational, agential autonomy, that capacity to understand what a constitutional sort of a governance structure, implies, and then to consent to it. And, here we're talking about, perhaps infants, human beings with severe mental disabilities, humans who are in a coma, who lack that ability to give even hypothetical consent because they're not sort of rational autonomous agents in the first place. That's the first problem. So those human beings are marginalized. And then secondly, and that's where the focus of our book lies, the second problem is, well, it excludes arguably all non-human animals who lack that capacity to consent to this governance structure. So we think that this legitimating principle causes the legitimacy gap. The way we propose to solve this is by proposing a different, more inclusive legitimating principle, and we call it the principle of due concern for the interests of all governed sentient beings, or in short, the all governed interests principle. So in short here, the focus is on giving due concern. So anyone exercising public powers will need to give due concern to all governed interest sentient beings. Due concern means respecting the basic interests of a sentient being. So respecting the fact that they have intrinsic moral value in virtue of being sentient, and respecting their basic interests, not trivial interests, but basic interests. You'll see also how we focus on all governed sentient beings, not all sentient beings. And by being governed, we roughly mean being under the effective control of the state. If you are under effective control, then the state needs to take into account, needs to give due concern to your interests to be legitimate. So with this, I'm handing over to John now, and I'm happy to keep on moving the slides. So just give me the go ahead.
All right, that's great. Thanks, Raffael, for that. And thanks to all of our participants and our audience. I hope you can all hear me fine. That's great. So I'll just carry on where Raffael has stopped. Raffael talked about the first part of the book, and now I'm going to talk about the second part of the book. And in fact, I'm only going to talk about parts of the second part of the book. So the second part of the book operationalizes what we do in the first part. So in the second part, we rethink basic constitutional principles, fundamental rights, proportionality, rule of law, and democracy to be compatible in a sentence-based constitution. So the question that we try to answer in this second part is, how would a sentience-based constitution operationalize or rethink or reconceptualize these constitutional principles? Of course, to find the full answer, you have to read the book, and the book is not as expensive as you think. especially with the discount code that we have given you at the beginning. So yeah, I'll just give you a little bit of the flavor of the two chapters, the one on fundamental rights and the one on the rule of law. So in the chapter on fundamental rights, we argue that in a sentience-based constitution, with some limited exceptions, the same catalog of fundamental rights that is being used for humans can, in principle, be read to protect also the rights of humans. Why is so? Why is this so? Well, because in our view, humans and many non-human animals share many interests and capacities, okay, which are actually already protected by fundamental rights. And so because of this communality between us and many non-human animals, the same catalog of rights can be suitably interpreted if there is sufficient political will and judicial will to cover the interests of non-human animals as well. And we also draw on existing ideas in the practice of fundamental rights to justify this expansion of subjects of fundamental rights, or possible expansion, you could say. And that is that the practice of fundamental rights so far has been characterized by progressive expansionism of subjects. So look at, for example, the history of the US Bill of Rights, which even though initially had as subjects of rights in this Bill of Rights were basically white men that held property, but over the time it has expanded to include non-whites, not just men. And so we argue that if we take these aspects of the practice seriously, then there is some ground to think that existing Bill of Rights can, in fact, be expanded even further to include the protection of the interests of sentient animals. We talk about other features of the practice of fundamental rights, such as the fact that there's no hierarchy between rights holders, that rights in bills of rights are worded in an over-inclusive way, and that they are framed in a general way. We explore in the book how these characteristics can actually lead to animals being protected by the same Bill of Rights that protects humans. Of course, now we don't have time, but you always have the ability to refer back to the book when you purchase it. In the last section of that chapter, we also exemplify the expansion of fundamental rights to animals by considering 3 rights: the right to life, the prohibition of torture and inhumane or degrading treatment, and the right to freedom. And we show how actually jurisprudence over in several constitutional catalogs of fundamental rights could be read, okay, to extend the protection of these basic rights to non-human animals as well. Okay, so if we, that's all I can say today on the fundamental rights. So if we shift to the other chapter, that, which I'm going to give you a flavor of today, that is the chapter on the rule of law. And in this chapter, we challenge the view that the rule of law is primarily concerned with the guidance of conduct. Those that have read the Raz will know that Joseph Raz famously argued that the rule of law, the basic idea of the rule of law is really to enable people to plan their lives according to law. But of course, this assumes that the subject of the law is a rational being that can rely on the law and plan their lives accordingly. But of course, this seems to exclude, or at least marginalize, a vast array of humans who, of course, are not able to plan their lives according to law because, say, they don't have standard rational capacities, okay? But of course, and for our purposes, it also excludes basically all non-human animals. And this exclusion, it seems to us, is unwarranted if we just shift our focus to a different conceptualization of the rule of law. If rather than thinking that the rule of law is supposed to help us guide conduct of humans, but rather is concerned with the restraint of arbitrary power, then we can see how the rule of law will always offer a measure of protection, non-contingent protection, to not only animals, of course, but also human beings that don't have personal autonomy. And in book, then we show how this shift from guidance on conduct, okay, to restraining arbitrary power, how if we rethink this basic idea, it follows that the rule of law offers all sorts of protections, even in its different conceptualizations of a formal, procedural, or substantive account. This rule of law offers protection to all sentient beings. So to conclude in this chapter, we argue that an inclusive account of the rule of law, which protects all sentient beings, human and non-human alike, protects them from arbitrary, not just state power, but also private power. And we invite you to read the rest of the book to get more of the details of our arguments. Thank you very much.
John, Raffael, thank you very much indeed. So now I'm going to invite responses. We'll start Dr. Angie Pepper, Senior Lecturer in Philosophy at the University of Roehampton. Angie.
Okay, thank you very much. Okay, so I want to start by congratulating John and Raffael on the publication of this insightful book. And I want to say that, like Sean, I read it with much enjoyment, much more than I thought I might get out of it. I think that you do a fantastic job of meticulously navigating complex questions regarding the relationship between the state and the non-human animals under its governance. And I also think that the book makes important contributions to constitutional theory, animal rights law, political theory, and animal ethics and animal studies more generally. Okay, so I'm just going to say a little bit about how I read the book, because I'm a moral and political philosopher, so I think that probably makes a little bit of a difference. And then I'm going to raise two a bunch of kinds of concerns I have given my own current preoccupations. Okay, so the book pursues two primary objectives. First, it elucidates, as Raffael and John just sketched, the shortcomings of anthropocentric constitutional theory and practice. Second, it proposes a framework for improvement. So to achieve this, John and Raffael lay the groundwork for a sentience-based constitutionalism, which demands that those exercising public powers ought to give due concern to the interests of all sentient beings they govern. So a notable strength of the book lies in its concrete prescriptions for transitioning from our current constitutional systems, which predominantly privilege human interests and instrumentalize sentient animals, to a future where sentient animals' constitutional worth is fully recognized. So it's the fact that you can kind of see how we get from here to where we need to go, which is a real strength of the book. And so with that in mind, I really appreciated the chapters on constitutional rights and the proportionality test and the democratic inclusion of animals, because in each of those cases, we're not simply told that this is what a just multi-species society requires, but we're shown how those things might be realized and operationalized. And because John and Raffael are after a theory that's realistically utopian, these utopian prescriptions are always rooted in our existing law and constitutional practice. So that helps to bridge the gap between the non-ideal conditions of the world that we live in. And it helps us to see how progress can be achieved through the reinterpretation or reform of existing frameworks. So now I'm going to move on to some more critical remarks. And I've got lots and lots of questions, I should say. I'm just focusing on these things because they reflect my own kind of current preoccupations, as I said. So while the book has many strengths, in my remaining time, I just want to raise a couple of questions that kind of arose during my reading of it. So the overarching motivation of the book is to address the legitimacy deficit inherent in current constitutions, which stems from their disregard or marginalization of fundamental interests of sentient non-human animals. So in short, since current constitutions, they do in fact govern animals, they're illegitimate insofar as they don't appropriately recognise or respond to the interests of those subjects. So to resolve this issue, John and Raffael advance a sentience-based constitutionalism, which, as Raffael explained, embodies the inclusive, legitimating principle that they call the all-governed interest principle. In short, this principle mandates that that those exercising public power must demonstrate due concern for the interests of all governed beings. In clarifying like the scope of all of those who are governed, they state, by governed, we mean that the legal and political frameworks and rules of a constitution have effective control over the lives, bodies, or habitats of beings who possess intrinsic moral value. And so that was a quote. They also suggest in the introduction that this principle, and again a quote, has no difficulty justifying exercises of public power over sentient animals and non-paradigmatic humans, end of quote. But I have some doubts about this. Okay, so let me begin by raising a concern about the varied nature of the state's relationship with the animals over which it exercises effective control. It seems to me that the all-governed interest principle assumes that animals are governed or subject to state power in more or less the same ways. And to my mind, this overlooks the importantly different relationships that exist, which I think might generate qualitatively different relations of rule. So for certain animals, such as foxes, seagulls, and lizards, and I've just picked some animals that live around me, those animals, they live amongst us, but they don't live in our homes. And effective control, while significant, doesn't manifest as an ongoing interference in the daily lives of these animals. Of course, as John and Raffael note, the organs of the constitutional system, including governmental branches, agencies, and public officials, can and sometimes do exert control over the habitat, environment, or even more directly, these animals themselves. So, for example, you might think about local council initiatives like the installation of bird spikes to deter perching or nesting, or the licensed culling of so-called pest animals such as grey squirrels, which previous UK governments have financially supported. However, while these animals are undeniably governed by the state in important respects, they largely retain the freedom to live in accordance with their own wills. Now, things are very different when we consider domesticated and other captive animals who are subject to organised social and political power in more thoroughgoing ways. These animals are deliberately positioned within use institutions that are ultimately sanctioned and organised under the constitutional system. Animals who are positioned in these institutions occupy certain roles that they are required to fulfil and are subject to effective control in a pervasive and ongoing basis. So, for example, farmed animals or animals used in biomedical research fulfill the role of livestock or research subject, which defines how they are treated and what, if anything, they are owed. No aspect of these animals' lives is ungoverned, and their whole existence is determined by the decisions of others, which means that they enjoy very little control over themselves or their environment. And arguably, these animals experience effective control in a fundamentally different way from free-living animals. And their complaints against the exercise of power are different in scope, intensity, and quality from those who are free-living. In the realistic utopia envisioned by John and Raffael, it is clear that many practices involving profound control over animals will cease. There is no place for institutions that inflict killing, maiming, torture, or impose unjustifiable limitations on non-human animals' freedom. The authors unequivocally assert that most, if not all, animal agriculture, the use of animals in scientific research, and the killing of animals for recreation are incompatible with a fully just, sentience-based constitutional system. And their conviction on that point, I think, is to be commended. However, it appears that a deeply entangled coexistence with domesticated non-human animals may still be possible within this realistic utopia. While not extensively elaborated, John and Raphael's utopian vision implies the existence of animal companions, suggesting that guardians will incur duties of care to those animals and duties to protect them from predators. And this is where I start to get a little bit uneasy. Animals bred to live in human homes are subject to pervasive and persistent forms of control across nearly all aspects of their life. And while this power is exercised by individual guardians, it is sanctioned and shaped by the constitutional system. Companion animals then are and will continue to be governed animals, a fact that John and Raphael don't deny. For the reasons that I just gestured at, though, with regard to farmed animals, I think the nature of the power exercised over companion animals differs considerably from that exercised over free-living animals. And this raises a critical question. Does a sentience-based constitution permit humans to continue breeding, raising, and cohabiting with animals as companions? If so, then this implies that human guardians would retain effective control over these animals' movements, their access to outdoor spaces, their dietary intake, their social interactions, their reproductive capabilities, their ability to raise their young, their access to medical treatment, and decisions regarding euthanasia, and so on. If this is right, that is, if a sentience-based constitution permits such arrangements, one might worry that the legitimacy deficit for these animals remains unaddressed. Arguably, even a reformed institution of animal companionship instrumentalizes animals for human benefit, significantly restricts their freedom, and exposes them to risks of harm. And this is a position that I've developed and defended at length with Rich Healy. What precisely grants humans the right to exercise such extensive governance over these animals in the first place? Importantly, the answer is not straightforwardly that it benefits these animals. Of course, we need to exercise power over existing domesticated animals to ensure that they have good lives, for example, by preventing them from eating toxic foods or protecting them from busy roads and so on. But that doesn't justify the deliberate maintenance of an ongoing system of power and governance over animals. And this leads to a second related concern. My initial apprehension stemmed from the unique positioning of domesticated and captive animals within the constitutional systems, where the power exercised over them is persistent and pervasive, and it seems to me to demand urgent justification. Yet upon reflection, the same question can be posed regarding animals not subject to such institutionalization, such as the foxes and the seagulls and the lizards that I mentioned earlier. What underpins our right to govern these animals? The problem is not merely that constitutional systems ignore or marginalize or disregard the interests of these animals, and that inclusion within these systems will rectify the issue. Rather, there is a more fundamental question which asks us to explain the very basis of our authority to govern them. Now, perhaps the answer lies in necessity, right? Wherever humans reside, other animals are present, necessitating frameworks for coexistence and thus a sentience-based constitution to facilitate this. However, I question how satisfying such a justification would be from the perspective of the governed animals themselves. Would they not, in fact, prefer complete liberation from human governance? And I will leave it there.
Angie, thank you very much. That was fascinating. So we're going to take the responses in order, and then Raffael and John, I'll ask you to comment and obviously open up to the audience. Pablo Costello, Dr. Costello, Research Fellow currently at Harvard Law School, and I have to add a former visitor to the center with a PhD entitled The Language of Zoodemocracy. So, Pablo, please make your comments.
Oh, thank you so much, Son. I'm very happy to be here. Hello, everyone. I saw some familiar colleagues in the attendees, and I have to say first that, like Angie, I want to begin by congratulating John and Raphael for writing such a superb book. And I have to say that unlike Son, I did expect that I'd like your book. I had high expectations and you fulfilled them, as usual. As both of you know, I am a huge fan of your work. I've been following it for several years, and it's just a pleasure and an honor to be here. In my commentary today, I'm going to focus on 3 points. First, I will discuss an aspect of animals and the Constitution that, in my view, makes an important contribution to centering the rich social and political lives of animals. Second, I will speak about sentience-based approaches and one of its potential limitations. And the third and final comment will be about the meaning of political participation. One of the things that I value most about animals and the Constitution is the conception of sentience it puts forward. Unlike traditional sentientist approaches that focus narrowly on suffering and happiness, Adenitire and Fasel argue for a richer understanding of sentience, one that includes a wide range of emotions, such as empathy, jealousy, disgust, grief, indignation, and love. I think this movie is crucial at a descriptive level because reducing animals' emotional lives to suffering and happiness fails to capture the richness and complexity of who animals are and what they actually experience. The nuanced sentientist approach advancing animals and the Constitution is also normatively significant because it contributes to creating the political and legal conditions for animals to flourish in a just society. To my knowledge, Adenitire and Fasel's conception of sentience is one of the most comprehensive and richest in the literature to date. Having said that, and as Raffael well knows, I also think that sentientism has limits. My next comment will speak to those limitations. One of the things I find most interesting about feminism, disability studies, and certain strands of political theory is that in those disciplines, it is common to find nuanced normative arguments that do not rely on sentience at all. Scholars in these traditions are often perceptive to the moral and political significance of families and relationships, such as friendships, as well as political communities, their cultures, and people's collective interest in self-determination. Against the backdrop of animals and the Constitution, what strikes me most from these literatures is that they often proceed, as I was saying, without referencing sentience. Other dimensions of our social and political lives take center stage. I say this not only because these other aspects of morality and politics matter normatively, but also because they seem important at the level of strategy and to win people's hearts and minds. In my experience, many people who are not vegan and who do not support animal rights are nevertheless touched by the idea that animals have cultures, families, and life-lasting friendships. In Animals and the Constitution, John and Raffael, you make clear that your sentience-based approach is not at odds with the kind of view I have just outlined. I read your position as not only intellectually robust and clear, but also humble, because as you emphasize, sentience is a sufficient, not necessary condition for moral and legal standing. Moreover, you also acknowledge that other aspects of morality, such as vulnerability, can ground animals' moral, legal, and political standing. That said, there is a question that remains unaddressed. Don't you think that, strategically speaking, it may be more effective to adopt what I would call a pluralist strategy that centers the richness of animals' lives, rather than one that focuses solely on sentience? To be clear, I'm not suggesting that we abandon your proposal. On the contrary, I'm thinking of an approach that includes your rich sentience-based framework and also incorporates the normative and political significance of animal cultures, friendships, social bonds, attachment to territories, and so on. I wonder whether you think that focusing on all these elements is a sound strategy. And this is a question that is as much for you as it is for me. And I just thought that today would be a very good occasion to raise it and perhaps talk about it later. My last comment is about the meaning of political participation, which is also connected, I think, to the question of starting from sentience rather than from animals themselves. In your book, you offer a nuanced discussion that draws on Sue Donaldson's article Animal Agora. In it, Donaldson proposes to use microboards as an institutional mechanism to represent the voices of animals. Microboards are organizations currently used in British Columbia, Canada, to take up the voices of people with disabilities. These microboards are comprised of individuals, such as carers and close friends, who are trusted by people with disabilities. These trusted individuals are in direct contact with policymakers to ensure that the voices of persons with disabilities shape policymaking. Donaldson argues that this model of representation could be extended to animals, allowing humans trusted by animals to serve as a conduit of animals' voices in political processes. Animals and the Constitution incorporates this idea. But one of the things that stood out to me as I read the passages that discuss Donaldson's article in Animals and the Constitution was the emphasis on how microboards would be used to identify and understand the interests of animals. If I understood your argument correctly, one of the key purposes of listening to animals through microboards and other means is, in your view, to better grasp animals' interests in order to include such interests in political decision-making. But if I have interpreted you correctly, I find this view of political participation only partially satisfying, because I think that zoodemocratic politics is about more than aggregating animals' interests. It also involves direct engagements between humans and animals, and among animals themselves. It requires negotiation, responsiveness, and some forms of deliberation between humans and animals. In fact, Donaldson herself says as much in Animal Agora. As she eloquently puts it, and I quote here, "Our good is not, or not only, reducible to pre-political interests to be counted and weighed in decision-making. Our good is something we come to understand and develop together through political community." I close the quote here. One of the questions that I was left with after reading Animals and the Constitution is whether you agree with Donaldson. Do you think that zoodemocratic politics goes beyond understanding and taking up the interests of animals? I say this because, as the quote by Donaldson I just read reveals, at the heart of zoodemocratic politics lie processes of deliberation that might allow human and non-human animals to co-author a shared conception of the good, not only taking up their interests. So that's my final comment. And to close, I just want to say and reiterate that I really enjoyed reading Animals and the Constitution. I am aware that the book is aimed at an academic audience, but it is written in a very clear and accessible way. And I really think that anyone interested in animal rights will find it engaging and rewarding. I didn't have time to comment the chapters on proportionality and the rule of law, and themes such as secularism and the place of religion under sentience-based constitutionalism, but I found them tremendously insightful and thought-provoking. For me, reading this book has been a real pleasure, and I'm certain I will return to it at least 1 or 2 more times, because it is just too rich to take in everything on a single read. So thank you so much, John and Raffael, once again for writing Animals and the Constitution. Congratulations, and I'm looking forward to hearing your responses and to the discussion during the Q&A. Thank you so much.
Pablo, thank you very much. Finally then, Saskia, Dr. Saskia Stuckey, Senior Lecturer Researcher at ZHAW. Saskia.
Yeah, thanks. Hi, everyone. Thank you for inviting me here, and congratulations, John and Raffael, for this milestone that we're all honoring and celebrating together here today. It's really, a wonderful achievement, this book. I can't really do it justice in such a short comment, but let me quickly preface my comment on the book, but with a brief observation about the state of animal rights theory, or where we're at right now. So I think we can observe a nascent trend towards specialization and diversification in legal animal rights theory. I think the past decades have brought about a pretty solid kind of body of general animal rights theory, and I think we're now at a point where we're kind of going into phase 2 of theory building, where there's more attention to nuances, to specific analyses of animal rights in real world context. So I very much kind of appreciate this nascent trend towards a bit more specialization and diversification. And well, also second observation, like having closely followed Raffael's work over the last years, I noticed that it keeps popping up a bit. So I assume this is Raffael's life goal, his big aim in life, to emancipate animal rights from the sphere of moral philosophy and to rethink animal rights through a legal lens. And I think this book, in both these aspects that I just highlighted, I think this book makes a significant contribution in this direction, in that it situates animal rights in the foundational real-world legal context of the Constitution. So this book zooms in on one and arguably the most fundamental aspect of the legal institutionalization of animal rights. So the Constitution is, of course, at least on the level of national law, the most foundational source of normativity and law in our legal system as we know it. So it makes sense to locate the starting point of any normative vision of animal law and animal rights. Here in the context of the Constitution. So that's a great starting point to think about the legal institutionalization of animal rights. And this book also does a very good job at showing that that contemporary constitutions are no different than any other legal source or legal text in our time, in that they are thoroughly and deeply anthropocentric. And this book also shows that our constitutions and constitutionalism need to change accordingly to accommodate animal rights. What good would animal rights be under an anthropocentric constitution that works to undermine animal rights at every corner? So I think it's probably a contradiction in terms to think about animal rights without also kind of rethinking what kind of constitutional system that would presuppose to have like real animal rights. So then this book then, of course, outlines the basic markers of a non-anthropocentric, sentience-based constitution that could serve as a starting point for fundamentally redesigning and renegotiating law's treatment of animals. So that's kind of my big view on your book, what it does, and like I have one maybe a bit of a critical comment, I guess, but you actually allude to this in your conclusions, so it's not something you haven't considered yourself. So my feeling when reading the book was that this endeavor that I just outlined, that I see as being the main trajectory that this book kind of seeks to give impulses for, that this endeavor entails more and is much more challenging than the book makes it seem, or then also it's more challenging and it entails more than merely reinterpreting some constitutional provisions or adding some animal-friendly constitutional provision. I think if we're talking about a sentience-based constitutionalism that respects animals' inherent value and rights, what we're talking about is basically a fundamental reorganization of the state. So constitutions, of course, they are the foundational legal texts of a nation state, and they deal with the fundamental organizational structure and the purposes of the state. And so, yeah, animal constitutionalism in this sense requires more than simply reinterpreting some key constitutional principles, adding some principles here or norms here and there. So I would submit that the sentience-based constitutionalism that you envision requires a more encompassing reconstruction of the state with this new animal mandate, and while we're at it, probably also an environmental mandate in mind. In political theory, this is often kind of talked about, well, in the context of environmental constitutionalism, we have the concept of the green state. So a state that is fundamentally transformed from like the social welfare state to a state that, yeah, tends to sustainability, to environmental protection. And I think something equivalent will probably also be needed for an animal constitutionalism, an animal state or something. So it's really a different identity of the state. It's not just some tweaks. There is a different identity. So I think what I'm saying is the work doesn't stop at the constitution. What is needed is a more fundamental reorganization of the state to serve the interests of its sentient population. So for example, judges. Judges need to be able and willing to apply animal rights in a consistent way. What I thought of that might sound a bit provocative, but what would be needed basically is a denazification of the judicial system. So like we need to expunge all anthropocentrists from public offices and replace them with sentientists to actually apply and interpret that new sentience-based constitution. Because if the same old guard of judges applies this new constitution, it would probably still not turn out in a sentience-based way that you sketched out. So I don't know what the equivalent of a denazification would be for animals, but I think something like that will probably be needed. Also, of course, there is international law that needs to be considered. How do the structures in international law affect the sentience-based constitution, for example, international trade law, etc. So that's kind of my general comment on how maybe more needs to be considered in this endeavor. And then, of course, I was particularly interested in your chapter on fundamental animal rights. And here, just allow me one provocative question, or maybe two provocative questions to end my comment. So it wasn't quite clear to me what permissible forms of killing animals you still leave room for. You kind of said what isn't permissible, but obviously there is an area of permissible killing of animals. And then, so here comes the provocative question. If the human and animal rights to life are of the same constitutional value as the non-hierarchical principle would suggest, and the right to life means that the state can kill animals to defend humans or other animals, which you state on page 94, wouldn't it follow that under a sentience-based constitution, the state could also permissibly kill humans to save animals? Humans, of course, are the #1 cause of animal extinction and like land change and environmental impact, which destroys animals' habitat and kills them in the billions. So can a sentience-based constitution kill humans to save animals? The other question is, and you briefly touched on that too, policing nature. What about animals among each other, animals who kill animals? You kind of say that that's not really in the realm of sentience-based constitutionalism, which, I mean, I kind of agree with, but where to draw the line? For example, cats, domestic cats, feral cats are they have significant impact on biodiversity and species loss. Shouldn't sentience-based constitutionalism lead us towards abolishing cats or confining them? So these are some tough follow-up questions to the right of life that I'm curious to hear how you would resolve them. But overall, yeah, congratulations. I really enjoyed the book. It's a wonderful contribution to theory. Thank you.
Saskia, thank you very much. And also thank you again to Pablo and Angie. So while the audience are reflecting on your presentations and also on the responses, as we said at the beginning, if you type your questions into the Q&A, I will read them out in a few moments. Before then, Raffael, John, would you like to reply to the responses you've had, or at least some of them?
Yeah,
Absolutely.
sure.
John, do
Yeah,
first?
happy to go
Entirely up to you.
first, and thanks again to the stellar Avengers level assemblage of respondents. We're really grateful for all your very provocative questions and the shower of praises. This book has been a book of love, by a book of struggles, and some of the, especially writing a book together, there's a lot of
Careful now.
bargaining. There's a lot of bargaining, and in the book, I think when there's been a little bit of, you know, differences of positions, I think we chose silence rather than, you know, maybe showing where the conflict was. I hope that's acceptable to Raffael. Okay. So let me go through some of the questions in order. So Angie provocatively asks at least one question. In fact, there are two very provocative questions. The first one is, can we have companion animals under sentience-based constitutions, and under what authority do humans actually can govern wild and denizen animals? Okay, and semi-wild animals, we can call them that way. So the first question, I think that there's been, Raffael and I have had this chat several times, and we have very different opinions. In fact, I'm very persuaded, Angie, by some of your comments, some of your work, arguing that a sentience-based constitution, well, in a just constitutional order, right? The institution of domesticated animals, companion animals, is at the very least, we should put a question mark. Because as you rightfully say, some of the interests of animals play second fiddle to the interests of the owners. The most obvious one is that owners typically only want to take care of a limited number of companion animals, so they will sterilize or neuter the ones they have, and of course they destroy the ability of these companion animals to reproduce, and so they interfere with just this very fundamental interest of animals to reproduce. I am persuaded that in a just constitutional order, companionship is not straightforward. Having companion animals is not straightforward. However, I think Raffael has been trying to convince me otherwise, that there are some basic interests. Yeah, at least in some situations, the lives of domesticated animals are better off, so that even in these institutions, you know, there's a trade-off of well-being of goods. But I'm sure Raffael can outline some of this better. Is there authority to govern animals in the first place? In the conclusion, we say something about considering especially wild animals or semi-wild animals as independent political associations, if not states, semi-independent, and that this level of let's call it federation, right? So the more a group of animals is able to govern their lives without reliance on humans, the more the freedoms and liberties, and the more the extent of their state rights, let's call it that, would be. Of course, they don't really have a constitution in the legal sense, but they have at least a cultural constitution, so to speak. So yeah, there is some tension, but we do realize that whether we like it or not, humans do have this impact on animals, and maybe in an ideal state where, you know, humans did not have any impact whatsoever on other animals, then there would be no need to set rules whether negative or positive, on the conduct. But in the real world, and because we want to talk to the real world, given the impact that humans have on other animals, the Constitution should set some limits and should empower the states to act in ways that respect the basic interests of animals. Pablo, I think very quickly, I agree with everything that you said. In the book, we try to be as pluralistic as possible, but we are humble, so to speak, because we want to write within the confines of the things that we know, and the areas in which we specialize, and our own, interests and traditions that we identify. So Raffael and I identify ourselves as liberals. We'll write in the analytical tradition. Of course, we have gained a lot of insight from critical animal studies, and from ecofeminism, and many of all these non-standardly liberal movements. And so we totally agree that others that have the expertise and the self-identity of all these traditions, scholarly traditions that you have pointed out, are just better placed than us to write on this. And yes, I think it's right that there are other approaches that can lead us to a more just future. And I look forward to you developing many of these insights in your forthcoming work. Saskia, do we need a green state rather than a sentience-based state? I'm not sure whether there's this opposition, but you are totally correct that we need a reconceptualization, not just of our constitutional order, but of the emotions and culture and ideologies that underpin any constitutional order. And in fact, what is more important sometimes than constitutional norms are constitutional cultures. That is, the informal arrangements or the informal ideologies that then inform the Constitution and then put them into practice. So more environmentally friendly culture would definitely help. A culture that values animal for their inherent value will definitely help. And you're totally right that this shouldn't stop at constitutional law. The culture and the practices of and the emotions that underline constitutional law are even more important than the doctrines, because they animate, they give real life to the Constitution. Yes, you're right that we may need to replace the current judges, etc., with judges that are more aligned, and politicians that are aligned with sentience-based constitutionalism. I think one tension here is that both Raffael and I are liberals, and we believe in the value of democracy, and so it's all of this. There is a tension, a revolutionary tension that I think that you're highlighting here. Can we bring about sentience-based constitutionalism in a way that respects standard rights, especially human rights, fundamental rights, and due process? And this tension, our clinging to liberalism and to liberal rights, I think shows that there is some tension with a transition from the current anthropocentric constitutions to a sentience-based constitution. Can we kill humans to save animals? If they all have the same constitutional worth, then yes. And in fact, even under the current constitution, like an anthropocentric constitution, sometimes it is permissible to kill humans in defense of other humans, but also property, right? So in some constitutional orders, even respecting, as long as the principle of proportionality is respected, it may be permissible, even in current systems, to kill humans that are, say, stealing your cattle, stealing your property, and or whatever. But there is, I think, a tension here between liberal principles and the transition, and I think I'll end there.
Yeah, I don't have very much to add. I'll just give my gloss on some of what John's already mentioned very capably, and also I'd like to express my thanks to all the brilliant respondents. John and I have already launched the book in a few places, but I don't think we've really ever had sort of animal law and animal ethics experts really share their thoughts on this. So this has been a real privilege, and I really just enjoyed listening to what you have to say and your really compelling sort of criticisms as well. So Angie, just to add to what John said, I think our framework, on the sort of the question of varied nature of the responsibility or sort of relationships that animals have with the state, I guess, and with human communities in the state, I think our framework of giving due concern to animals doesn't exclude that, right? We say take into account the basic interests, and I think, looking at species, but also the relationships within which these species are, will be part of taking into account the basic interests of, each and every individual animal. So in other words, I think, we're not requiring all animals to be treated equally. Of course, we're open to, a sort of a more equal consideration, if you will, approach that takes into account those relationships. So I think our approach is open to that, doesn't require treating all animals the same. And nor will we reject, I think, ruling out the type of extensive governance of animals that you've highlighted in some types of, sort of companion animal cases where, clearly it's humans dominating animals. Our framework does not endorse this at all, right? The question that remains is, and I think, John suggested that I have a sort of fleshed out approach here, which I don't, I'm afraid, if only I had, but I think some version of animal companionship is possible within sentience-based constitutionalism, but it is certainly not the sort of, the sort of extensive, excessive governance that you've mentioned. So that would not be compatible, but some version of coexistence, I think, would be compatible. But maybe John has some other thoughts, and we can chat about this in the discussion. Just to add on the question of wild animals, I would just say that our theory does not require for animals to be governed, right? So we don't think it is necessarily desirable to be governed by the state. It's a separate question. Perhaps in some contexts it is, in other contexts it isn't, taking into account also the fact that, state powers can be abused and all of that. And we say in the book that there are animals, if you're thinking of what like big spaces like, Siberia, for instance, or, sort of northern Canada, animals that are on the territory of a state but are not governed by, the sort of public powers in that constitutional framework. And we don't take a stance on whether it would be desirable for those animals to be brought under the governance. In fact, it probably arguably wouldn't be, but we basically said we don't touch that space. Pablo, I really like this point about pluralism, like John did. And the only thing I would add here is just to say, I think we try to make some effort to show that, sentience should be understood more broadly than just, pain and happiness, right? So we draw on obviously some, the brilliant, sort of studies that have been conducted showing that animals obviously are capable of love, of, complex emotions like jealousy, grief, and, it can factor in friendship there as well. So I think it's sort of suitably broad understanding of sentience doesn't necessarily, and in fact doesn't, I think, exclude the types of relationships and other moral factors that you are rightly highlighting as both morally and strategically relevant. So I think there's some common ground there. The microboards, I think you're right to push us here. I think to the extent that we gave the impression that it was just a matter of taking into account animals' interests rather than, allowing them to be co-authors and challenge the frameworks we have, then that was a sort of a mistake. Because if anything, we want to sort of distance ourselves here from the, from Alistair Cochrane's view that we appreciate in many respects, that focuses more on equal consideration rather than equal participation, as we say, right? So for us, it's all about participation. So to that extent, everything you said is correct, and we should have done a better job, making this clear. Then briefly on Saskia, I guess it's true that I'm trying to emancipate, sort of animal rights law from moral philosophy. It does sound like I, hold all moral philosophers in disdain, which I don't. Just to, put that out there for the record. So I love the work that, everyone's doing in the moral philosophy space. And I guess the work that John and I are trying to do in this book, at least, is, building on that important work and showing how in animal rights law, there are things we can learn from that, but also things that we can do perhaps differently, because the law sometimes works differently from how, perhaps, more idealistic moral philosophical conceptions work. And then just lastly, to agree with you that, yes, I think there needs to be a broader look at not just the formal constitution, I think, which is the focus on of our book, but what's called the material constitution, right? So the culture, the economy, all the material factors that ultimately determine how judges think, how people think, the kinds of things that are possible in a legal system, in a constitutional system, because you can have the best, constitutional rights guaranteed in a constitution in the text. If there's no support for it on the ground, then that's not going to help animals very much at all. So I entirely agree with you that there should be more attention, shed on this. And Jess Eisen, for what it's worth, I think is doing some really crucial work on that front already. But I'll leave it there. So thank you very much.